functionaries of CMA and all the ladies and gentlemen. Uh, uh, means I will make a very brief presentation on the labor codes, and I will try to be very brief because most of the things have been stated by some of the speakers who has spoken before me. So just I will make a brief presentation. So just to give you a overview of this thing, the present government has brought in the labor reforms in such a way that the welfare and the safety of the workers is the utmost important. So while attempts have been made and there are a lot of things have been done for ease of doing business, but government has ensured that the welfare, social security and safety of the workers are adequately incorporated in the labor laws. So now I will start the presentation. Next slide. Okay. So my presentation has the six component. One is the rationale, the codification, the rationalization of provision, benefits to employees and employer, and social protection. So in the codes we have tried to ensure that the balance is maintained with respect to interest of the employees as well as employers. And the focus is on the social protection and particularly to the unorganized sector workers. Next slide. Next. See, these labor reforms have their genesis, say quite before. So why these labor codes were brought. See, initially we had around 44 central labor laws. There were multiplicity of labor laws and there were multiplicity of authority, and majority of laws were enacted before independence. So there was a move that now that the country has come out, has traveled along, so that the labor laws should reflect the realities of the today's India. So accordingly these were done. And also the National Labour Commission and employer and workers had made the representation that the labor laws need to be reformed. Just to give you an overview, out of the 44 central acts, the 12 acts have been repealed. So if you see the journey where we have come out, say now we have come from 44 labor laws to now we have 4 codes, plus there are 3 acts which have not been abolished. First to take you the 12 labor laws which have been repealed are basically have their genesis with respect to related to this levy of the cess for various types of workers. So these were repealed, and the requirement had come because we had done a very major labor reform, major taxation reform in this country, that was the GST. So with the coming of GST, the levying of the specific cess was done away with. Now I come to the 4 labor codes. Basically, the 29 labor laws have been subsumed in the 4 labor codes. And just to give you glimpses of this, the Code on Wages has subsumed 4 acts, which is the Minimum Wage Act, Payment of Wage Act, and Bonus Act, and the Equal Remuneration Act. And one of them was quite old. It had been enacted in 1936. Yeah. Next, if you see the rationalization, how this government has done a lot of things to simplify the things. See, earlier, this thing the sections. If you see the total section, when there were the 29 laws, there were the sections which were around, say, more than 1200. Now these have been reduced to, say, around 480. So that's why we have done a lot of rationalization. There is a consistency in the definition across all the codes, and the provisions have been simplified. Next slide. Next. Out of these 4 codes, the first code, which is Code on Wages, was enacted in the year 2019, and the rest, the 3, the Code on this Industrial Relation Code, then Occupational Safety Code, and this Code on Social Security were enacted during 2020. Next slide. See, next slide. Now I come to the benefit which these codes gives to the workers. See, means these are spread across all the 4 codes. Uh, the important step taken is that the universalization of minimum wages. So now the minimum wages will apply to all employments against the scheduled employment. So if you see that this is the starting point of the social security to the workers. So means when we ensure a minimum wage, we also ensure that they have a minimum standard of living. Along with that, we have also introduced a concept of floor wage. So the means the floor wage sets a limit below which no state government can reduce the minimum wage. At the same time, if the wages are above the floor wage, those cannot be reduced. Similarly, now there is a total gender equality, and there is means prohibition of discretion in recruitment and the wage payments. And now the timely payment of wage has been made mandatory. So means all the employees should get their wages by 10th of the next month. Next slide. Similarly, means the code on wages also takes into account that means depending on the skill level and the condition, like if someone is working in a difficult condition and also it is a geographically difficult location, the wage has to be fixed taking into that account. See, and means one of the important thing is that if there's in the earlier regime, if there was say some dispute, then they had to go to the courts. Now a system of appellate authority has been introduced so that the time is also reduced and the cost of litigation also comes down. And similarly, if someone has not been paid the wages, the limitation period has been increased from 2 to 3 years. And as I said that all the payments of the wages has to be made before the 7th of the next month. And one more, the pro-worker initiative is that if the allowances exceed 50% of the wages, then they will be made part of the wages. Accordingly, there will be enhanced maternity benefit, gratuity, and all those, the EPF and ESIC contribution. Next. Now I come to this industrial relation code. See, means for the first time we have introduced this fixed term employment. So the fixed term employment is that instead of say depending upon if say a company has got an order for say 2 years or say means for 1 year or something like that, that they can hire a worker directly and they will get all the benefit at par with the regular worker. And secondly, also the fixed term employee will also get the gratuity after completion of 1 year. For other, it is means the 5 year. So that there will be an encouragement that there will be formalization and direct hiring by the companies. And if the worker is say laid off, then there is a reskilling fund which will be contributed by employer. And also the concept of negotiating union and negotiating council has been introduced. Now the this for the executing the industrial tribunal has been made 2 members. One is judicial and one is administrative instead of 1 member, so that in the absence of a member, the tribunal will function. Next slide. Similarly, means the government has ensured that there is a gender equality. So in the grievance redressal mechanism, there will be employer and employee will have equal representation, and the representation of the woman worker will be in proportion to their participation there. Similarly, the definition of worker has been expanded. Now this also includes the sales promotion employees and the working journalist also. Means to ensure that there is no disruption in the economic activity, now the 14 days notice is mandatory for strikes and lockout. Earlier it was only for the public utilities. Similarly, the penalties have also been rationalized, made in line with the gravity of the offenses. One of the important means the government's initiative is compounding of offenses. So instead of going in a legal thing, means they can pay the amount and then but this compounding offense is only if it is not committed again, say within the 2 years of the means the offense committed for the first time. Next slide. This is a very path-breaking initiative of the government in terms of the social security. Now the social security has been expanded. Now it will cover all the unorganized workers, and the welfare will include this life, disability, health, and old age benefits. Now the ESIC coverage is also made pan-India in the sense that it will be applicable across the country. And though it is mandatory for workers where the say employer is employing more than 10 or more workers, now even for less than 10 workers, the employer and employee can voluntarily join this. So means the social security will be, the health and the other facilities of the ESIC will also be applicable to and available to the unorganized workers also. Similarly, see, means important provision has been made that if a worker is working in a hazardous process like say lead making or something like that, so means there is a schedule, then even if there is a one employee is working, then that unit has to be mandatorily registered under ESIC because they are exposed to more dangerous working. Now, EPFO coverage has also been made universalized in the sense for 20 and above it is mandatory. Now, even say those less than 20 can also join. Now the limitation, the time limit for completion of inquiry by EPFO has been confined to 2 years, and similarly the EPFO cannot suo motu start the old cases. Means for the first time there is a legal recognition of gig and platform workers, and there is a specific definition given, and also there is means the provision is for the welfare of the gig and platform workers. And as per the budget announcement, the government has drawn a scheme for them. Next slide. Means all the benefits of the Maternity Benefit Act have been retained here. So means now it is mandatory to give a 26 weeks paid leave to a woman employee, and option is also there to work from home after the maternity. And all the establishment having 50 or more workers to have a crash at a suitable location. See, earlier the requirement was there if say only means the 20, say means the 50 female workers were there. Now it has been made gender neutral. So wherever there is a 50 or more worker, then the crash facility has to be provided. Now there is a flexibility is given that instead of setting up the crash facility there itself, then they can access the services of the crash facility provided by NGO or say the government run. So that's there. Similarly, for the building and other construction worker, there is a means for the payment of cess, the employer can make a self-assessment. Then skill development is also there. So there will be National Career Service Portal. Next slide. This is the OSH code, which is Occupational Safety and Health Working Condition. Now this will apply to all the establishment employing 10 or more worker. See, earlier this occupational safety and health was restricted to 7 sectors like factories, mines, plantation, transport, construction, dock and BD. Now it will apply across all the establishment having 10 or more employees. In case of this, the mines, ports and dock, it will apply even to means where there is a one worker, or if it is being carried, the unit is carrying out the hazardous or life-threatening activities. Now there are means very important means the provision made in the code related to encouraging higher female labor force participation. Means for the first time the government has allowed women to work in all types of establishment and in all kinds of work. Similarly, the women have been allowed to work at night in all establishment with their consent and the safety. So these are means a very progressive steps which this government has taken. Similarly, means the opportunity to earn has been there because the overtime limit have also been enhanced. Means one of the aspect which the worker find is that often if they go and make some claim about their entitlement, then it is said that okay, you are not my employee. Now there is a formalization of employment because now the issue of appointment letter has been made mandatory, and the government will specify in their rules means what format of this appointment letter is there. And similarly, to protect the health of the worker, now there is a provision for mandatory free annual health checkup for employees above a specified age. So this will also promote their productivity and also take care of their health aspects, so that because now many diseases are taking place, if the annual health checkup is undertaken, those diseases can be identified, and the follow-up the medical facility can be provided. Now, if you see the two things like means the free medical health checkup and the universal coverage of ESIC, now means these two go very complementary. Next slide. Means one of the important component of our those workers are the migrant workers. Now this definition has been expanded in a sense that earlier only those migrant workers which had come through the contractor were considered as a migrant worker. Now those who also come on their own will be considered, say means they come from one state to another, will also be considered as a migrant worker, and they can also register on a self-declaration basis with means where their Aadhaar will be seated. And the government will also ensure that there is a portability of ration available to the interstate migrant workers. Similarly, the definition of this working journalist and cine worker has been broadened. Now it will include workers employed in electronic media and in all forms of audiovisual. Earlier, they were only those who are working in the print media were considered. Now the definition of audiovisual worker has been extended. Now it will include the stunt person and dubbing artist. And the audiovisual production has also been expanded to include the web-based serial, talk shows, reality shows, and sports shows. So means the entire gamut of the employees working in the audiovisual production will now be covered by the codes, and it will expand the social security benefit and the safety to them. Next slide. One of the important thing is that means now the safety standards will be set by the central government. So there will be uniformity of safety, health, and welfare facilities across the establishment. Like means there will be the provision for canteen facilities, then means the provision for welfare officer in factories, then crash facility that I had told you, and also the restroom, ambulance room, and the first aid room. And also see means earlier what used to happen that earlier the court were finding it difficult to give the benefit in case of an accident. Now the legal heirs can also get in the case of means the death of that employee. Next slide. Now, so means so far I have talked about means what are the benefits for the employee. Now I will come to means how this is means these codes are going to benefit to the employer also, means from the ease of doing perspective. As I said that means the sections have been reduced from more than 1200 to around means 480. The rules have come down from 1400 to 351. Now earlier there used to be in all those 29 acts there used to be 31 returns. Now these have been combined and there will be only single annual electronic return. Similarly, the forms have been reduced from means 181 to 73. The registers from 84 to 8. Now there will be a single registration. Instead of 8, there will be a single registration. This will be electronic registration. Now similarly, the licenses have been reduced from 4 to 1. And the important part is that the decriminalization. Decriminalization means the sections where we have done away with the means the penalty in terms of imprisonment. So now means from 87 it has come to 22. Out of those 22, 16 are compoundable. The 6 which are retained are those which relate to means where say due to some safety measure there is a death. So in that case the imprisonment has been retained. And similarly, if say employer has deducted the say the PF and EPF contribution and it has not been deposited, then it will be also be liable for imprisonment. But imprisonment will come at a later stage. First there will be means the process of means the payment of penalty. Now the compounding has been introduced. This is for the first time, and the important part is that the improvement notice. Say if some inspection takes place and some violation is found, then it is not immediately the means the prosecution will start. Now means the first that implementing authority or the agency will give a notice, specify that these are the shortcomings, you improve those things. This has come also because now the role of the inspector has been changed from inspector to facilitator. So as a result, means the government is working on the principle of the trust-based compliance. So that means whenever a violation found, then an opportunity will be given to comply with that. Next. So similarly, just to summarize this now, this one, there will be a single registration, single license, then single returns. Similarly, the license for the contractor will now be valid for 5 years instead of say 1 year, which is the provision right now. Means for the threshold for seeking a license has been increased for contract labor from 20 to 50, and in the case of factory with power from 10 to 20, and factories without power from means the 20 to 40. So means this thing I had informed about this, the imprisonment which leads to decriminalization. Next slide. So the role of the inspector has been changed from inspector to facilitator. Now they have a responsibility to guide them. So that means the employer and the workers. So that means they are more compliant. Similarly, there will be not an arbitrary or subjective inspection. Now this will be a randomized web-based inspection system has been is going to come into force, where that the inspection will be based on a risk-based assessment. And there will be higher female labor force participation because we have allowed them to work at night and in all types of works. The crash facility is there. There is a leveraging of technology, and also there will be flexibility in the working hours, and the overtime flexibility has been given to the appropriate government, like the state government set the working hour limit for the workers in the factory sector. Next slide. See, means here we are indicating how this government has achieved. See, like our social security means the coverage has increased from 19% in 2015 to 64% in 2025. Now we are second in the world to have a social protection, means at least one form of the social security is being given to the workers. So means we are ranked second in the world right now. And India has also received this prestigious International Social Security Association award for outstanding achievement in social security. Thanks.
Anyone having any questions, please feel free to ask.
Yeah, means just to add, means to clarify more and simplify more, the ministry has also placed this FAQs on our website.
Hello, sir. I have a question here. So the code has been implemented from 22nd of November. So now the state government has to implement from their rules. So effectively, when this code will be implemented pan-India basis. And second question is that because the state government has to implement, it was in phase-wise. Suppose a particular state can implement, say, maybe by one month down the line. So what should be the effective date where the pan-India implementation should be implemented? Yeah.
Means just to answer your question, see, means those codes were made effective from the 21st of November this year. So if you see that means the press release which was issued on that day, and if you read the second last para and the second and the last sentence, it says that those codes, means provisions of the codes which do not require formulation of rules or regulations have come into force from that date itself. And those sections which need the formulation of rules will be effective from the date when we issue those rules. Now, see, in that also we had said one thing, like say means while undertaking this means the formulation of codes, we had carried out extensive consultations. And means for that means we have said that we means the central government, I will speak on behalf of the central government, that we have said that we will be putting out the draft rules in the public domain for consultation for 45 days. And after that we will be finalizing. So this is the process which we are going to follow. So means while making the codes, we had followed an extensive public consultation. The similar approach will be followed. Now, as far as the state government, so we have been holding a meeting with them, and we have been advising them means what approach we are following. So because it is a concurrent subject, so there are certain things which the constitution and the code gives specifically to the state government. I think the state government have to take call on that.
I'm Venkatraman. I congratulate on behalf of the Institute for bringing this new labor laws. Probably all of us are aware of any legislation over the period change, there will be pros and cons. Already last month, all labor unions all over India have planned for this thing, agitation, etc. It does not mean they're against it. Probably some sort of a modulation compared to what is 25 today or even for 2047 should be there. My suggestion is, even though you have put it in the website, etc., the suggestions, etc., there are institutes like that, our CMA institute, other institute. Particularly, there are a lot of problems with regard to small industries, SMEs. Hitherto, they were enjoying so many benefits. Suddenly, they are asked to do this. While on the one hand, we say we are simplifying it. On the other hand, SMEs already finding it as a burden. I'm only suggesting that the central government may authorize this institute to have some sort of a discussion with the association and other thing. They should be enabled to represent on behalf of the industry or the no problem. I'm able to hold it. Okay. All problems could be centralized to professional bodies, and we members also can contribute it, help in implementing smoothly this suggestion. One is that. Secondly, some sort of a feeling that it is anti-labor, that feeling is there. That should be avoided through this institute. Thank you.
Okay, just to respond, say means after the courts were notified on the 21st, say means we have held a series of meetings, means madam will also speak means when she addresses, that at the minister level, at the madam level, and at the secretary level, we had interacted with the employers association, industry association, and also we are interacting very regularly with the state government, because if you see that the 90% of the laws are going to be implemented in the state domain, so we are constantly interacting with the state government to facilitate them. And secondly, about that MSME, we immediately after the courts were enforced on 21st, we held a meeting with the MSME organization, and they had wholeheartedly welcomed this. And the only request they had made that because we are not as big, say, in terms of resources like a bigger company, so just to facilitate in the implementation. But they were all on boards, and there is going to be a constant interaction with the industry and also the trade unions. So that has been done, and also with the state government. So that's there. And as far as your interaction with those associations, so you can do it. So it is not something, same the government is for everyone. So we cannot mandate that you do. So if you want to interact, you can interact with the industry association. Thank you.
Sir, I'm Girish. In one of your slides, I saw 44 existing labor laws. Out of that, 29 have been subsumed, and these 4 labor codes have come. And apart from that, 12 have been repealed, totally making it 41. I think 3. What were the earlier laws? And
see, those which have not been repealed are basically those related to prohibition of child labor. So then there is also bonded labor. So those have not been repealed, because that we cannot do now, because repealing a say child labor act will mean that we have to do that thing. So that thing cannot be done.
Okay, these are continuing in the same present form.
If you see, basically the 3 those acts which have not been repealed or subsumed in the code are this Child and Adolescent Labor Prohibition Act 1986, Bonded Labor Act 1976, and there is also a Provident Fund Act of 1925. So because that is something which was spread across same as many organizations, so those have not repealed.
Sir, another point is, so if I am a company having a presence in the entire country, maybe 3-4 locations.
Yeah.
So here the central government has notified the act. State governments, maybe some opposition governments, we do not know what is the time frame within which they are going to bring this or adopt this new rules or regulations. So with this present political scenario, when do you expect this in totality will be implemented? So because as a business, I am concerned as a business, not as a politician. So how do we, maybe I am concerned only from my business. I am having multiple locations. So how do we address this? So uniform code is not there. Again, some
No,
state
see, it is labor is a concurrent subject, so it is means well established, means where there is a central law, the central law will prevail. So on that thing, anything else?
Yeah, I think.
Hello, last question. Earlier, we professionals used to work for companies and arrange for a lot of licenses under the old Factories Act. Now, because of the state government, are we going to have still the Factories Act for license, or under the new act we have to take the factory license? Because we still the government departments in the state government is working on that and all those things. Labor Ministry and the state government.
See, means right now there is also a license is also there for the factories, and also for the contract labor it is there, but now the thresholds have been increased. And secondly, that the means the unit.
I am talking about the factory license.
So means factory license is still there. The requirement of the factory license, that is the threshold that has been increased from 10 to 20 and means 20 to 40 depending upon the use of the power. But there will be a single license now. That unit can also take a single license for factories, for means this one also. The contract labor,
Contract labor.
Yeah, and also for this means the BD and cigar.
Thank you.